Hey guys, in this video, we're going to talk about a wonderful story involving our client who has been here for 22 years and she could finally get her green card now. We're so excited for her. She came into the US in 2000, guys, and she faced a lot of roadblocks along the way. In this video, I'll share with you exactly what her problems were and why it took 22 years to get to this point. If you're new to me, welcome to this channel and to my video. I'm Latoya McBean-Pompey, an immigration lawyer in New York, working with clients nationwide and around the world on solving complex immigration problems. Reach out to us at mcbeanlaw.com or at 516-866-3900, where you can request to meet with us about your problem or about your case. Also, guys, don't forget, subscribe to this channel and hit that notification bell so that you'll be the first to get notice of these videos each week. We also have a terrific newsletter that we email to our subscribers each week. We answer Q&A questions from you. We also do shared immigration news. So subscribe to that as well at mcbeanlaw.com. Now, here's what happened in this case. The client came into the country in 2000 without inspection. She was immediately, actually, not too long after coming in, she was issued a notice to appear in immigration court. She was placed in removal. She applied for asylum, and the judge denied her asylum application as well as her request for withholding of removal. Now, when that happened, she appealed the decision, and the Board of Immigration Appeals dismissed or denied her case. And so after that, she got married to her U.S. citizen spouse, guys, and they've been married for over 15 years. And you would think, well, she has a U.S. citizen spouse. What in the world? Why wasn't she able to get her green card many, many years ago? And I'm going to tell you exactly why she wasn't able to get it those many years ago. And it's because, first of all, she entered without inspection. When Haiti was designated as a TPS, or temporary protected status country, she was able to get an opportunity for a lawful status here through TPS. But guys, as you know, TPS is not residency, right? It is not a green card. But through her TPS, though, she was able to apply for advanced parole, and USCIS approved it. They approved her advanced parole, which then allowed her to leave America and come back in and have a record now of lawful admission. After that happened, she applied for adjustment of status to USCIS to obtain her green card. USCIS made an error in their decision when they denied her of her green card. They argued that they don't consider her an arriving alien anymore because she left with TPS and she came back in and she has a record of lawful admission. Therefore, she is no longer an arriving alien, and she has an outstanding removal order. Therefore, we do not have jurisdiction over her. Then she felt stuck, and a couple of years went by, and then I popped up in a video kind of similar to this one and got on her radar, and her and her husband reached out to our firm. We had a consultation and we said, you know what, USCIS was very wrong in their decision those years ago, but we know that there is a way that we could fight this and help you. And so rather than us going back to USCIS with another green card application and arguing that she has a right to get it through them, let's settle the case with ICE. Let's see if ICE can join us in a motion to reopen your removal case and terminate it. So therefore, USCIS will no longer have any argument about jurisdiction, because the next time you go back to USCIS with your green card application, they must approve it because you're eligible for it. And so we took her case to ICE and we argued some things involving her U.S. citizen husband and her background. She has a clean record aside from the immigration violation of coming into the U.S. without inspection, and some other things we argued, of course. And ICE agreed with us, guys. And so now she has this opportunity to now get her green card through USCIS. If any of these facts sound familiar to you because maybe you're in a similar situation, you should have your case looked at by a licensed immigration lawyer, or you can reach out to us so that we could take a look at your background and see if you're a good fit for this process. And we do this process for clients nationwide, okay? Nationwide. Not everyone is eligible for this, guys. Not everyone is eligible. So that's why it's important to speak with an expert about these matters to see if, you know, the government got it wrong about your case, and if the government got it wrong, whether there's a way to fight it. All right. So I hope you found this encouraging. It did encourage me and my staff, our team. We're so happy for her. When I called her with this decision a few days ago, she just started praising the Lord. And then she came back on the phone and said, and I'd also like to thank McBean Law. And I said, ma'am, you got it so right. Praise God first. Thank us next. So guys, reach out to us at 516-866-3900. And I have to say, all cases are different. All facts are different. Just because we were successful with this case and other cases does not mean that we're going to have the same results in future cases. So I just have to mention that disclaimer here. Reach out to us and we'll be glad to tell you whether you have a chance or not for this type of process. And guys, thanks so much. Share this video with others and I will see you in the next one. Bye-bye.